Hi, this is a slideshow that I put together very quickly to discuss some of the differences between power of attorney versus guardianship and conservatorship. I am not a lawyer. This is not legal advice. These are just some of the things that I learned when I had to go through this whole process with my elderly mother. If you Google family law near me, you will find plenty of law offices that can give you more detailed information. So what is a power of attorney? It is a document that gives you permission to make financial decisions for another person. That's it. It allows you to do financial transactions. It can allow you to do legal transactions. Some institutions require a power of attorney to be processed internally before you can use it. In other words, if you go into a bank with a power of attorney and slap it down and say, I want to withdraw all this person's money, they're going to be like, yeah, nah, that's not going to happen. We have to process this internally. It may take a couple of days. So if you need to do something with a power of attorney, some planning ahead may be necessary. Spouses should have power of attorney for each other. If somebody gets into an accident and goes into a coma, you need that power of attorney to maybe sell property or something like that. And adults like me should have power of attorney for their elderly parents. It's probably not wise to use some generic power of attorney forms that you find on the web. I recommend, again, contacting a law office. Power of attorney statements must be notarized. That means you have to take it and sign it in the presence of a notary public and have them notarize it. Power of attorneys can always be revoked. No matter what the power of attorney says, the subject can always revoke that power of attorney and say, no, this is no good anymore. It should not be honored. Power of attorneys can be limited. So if I'm giving you a power of attorney, it may be for a certain set of dates or other certain conditions. I might have a power of attorney for my spouse, but only while we're married or while we're still living together, things like that. Courts are not involved in power of attorney cases. You don't have to go to court and have a judge approve a power of attorney. It's just an agreement that you have with another person, and the document, the power of attorney document, is what proves that. That's why it has to be notarized. Power of attorney does not let you force the subject to do anything against their wishes. If I give you power of attorney, that doesn't mean you can make me do anything. It does not remove my agency. Just because I give you power of attorney with limited rights to my checking account doesn't mean I can't also do something with that checking account or, again, revoke that power of attorney. If I give you power of attorney, you have to understand why you're receiving that power of attorney, and you have to act in good faith and with my permission. If I give you power of attorney and you take all my money and go to Mexico, that's still against the law, even though I gave you power of attorney. Okay. Conservatorship. A conservator is similar to power of attorney. It has to do with financial and legal matters, but that's all. That's what a conservatorship is. But a conservatorship is appointed by the court. You have to take somebody to court to be named that person's conservator. Once you are a person's conservator, you and you alone are responsible for all of the subject's finances. The subject is then removed. They no longer have any agency over their own finances. Only you, the conservator, are now responsible for all those. Now, you can include the subject or you can inform the subject on the decisions, but you don't have to. The conservator is responsible. They don't need the subject's permissions to do whatever they need to do. And it must be with the long-term well-being support of the subject in mind. And usually you're talking about the financial health of the subject, not their well-being. That gets into guardianship, which I'll talk about in a minute. When you are a conservator, there is a lot of paperwork involved. You have to keep receipts for absolutely everything down to the penny, and you have to file reports with the court on a regular basis. In Virginia, I think it's every 6 months. Also, when you're a conservator, you have to be bonded. If I'm your conservator, I have to buy a bond that protects you. Guardianship. A guardian, unlike a conservator, which is all about the financial, guardianship is all about a person's welfare, well-being, and health. So a conservator does not make decisions about a person's health and where they live. That's guardianship, and that's where the difference is. Again, a guardianship, just like a conservator, must be appointed by the court. A guardian can make decisions about doctors, medications, treatments, where the subject lives. Anything that has to do with that person's well-being is the job of the guardian. So guardianship and conservatorship are usually done at the same time. You do have to file a suit in circuit court, at least in Virginia, to become somebody's guardianship or conservatorship. You usually have to have an endorsement from a doctor, a signed statement from a doctor saying, yeah, this person is pretty much incompetent and they need somebody else to look after them. In Virginia, and this is usually the case, you have to pay for 2 lawyers. You have your own lawyer, and you have to pay for the lawyer that will represent the other person. And they will help them in court and basically give the court an unbiased opinion about if this guardianship or conservatorship is needed. The whole process takes forever. It's very expensive, and there's a ton of paperwork. From the time I started it to the time I was granted guardianship and conservatorship, it was probably about 6 months, and it probably cost, including the bond, about $7,000 or $8,000.